Just because I think it's an easy document to refer to, especially if the judge does order a restitution plan, which is required by statute. And if they don't, then it's all collections.
I'm wondering if there's a way, as y'all are talking, I'm wondering if like the condition itself is short and succinct, kind of like DOC's, but then on the form that's utilized for the general conditions, there's a page just dedicated to the fines and fees, kind of like what you were talking about, Spence, where it's listed out anything that they could possibly receive kind of a fine or fee or court costs associated with. And that gets filled in and kind of attached to that conditions of supervision. I don't know if that would like bridge the gap so that it's user friendly for the courts and the supervision staff, but then it kind of separates it from the general conditions a bit.
So Jennifer, would that mean that it would be we'd have a general one on the front and then the specific ones could be mapped out on a second page or third page, whatever, through special conditions?
I don't know if it would be special conditions or just like fines, fees, court costs, like restitution, like a financial, like here's all of the financial information. Just throwing it out there. I don't know. We can definitely go kind of wherever y'all want, but.
What would you see, and sorry, this is Spence Cohen, what would you see as the benefit as to having it separate versus just in one section?
I was just thinking visually,
Okay.
like having like general conditions and then like here's a page that is all of the financial obligations.
Okay.
So that's all I was thinking was kind of visually. I don't think there's a right or wrong here.
Stephanie, you are involved in this a lot with not only making the recommendations to the courts through your PSIs, but then following up. Kind of, what are your thoughts on that?
I would just second what Spence had said. I think we need to have something on there. I don't know if we have to spell out the exact monetary amount or what the fees are associated with, but I think we need to have something to be able to tell our clients when they come in. With it being a court order that the judge has said, it just makes it, I like all the court orders in one spot.
This is Randy with Reno County. I agree with what Stephanie is. The problem I think that we run into here at least is if we tried to outline all those, we really don't know any of the costs.
Hey Randy, this is Spence. It might be just me, but I think you keep cutting out again.
I was good on the meeting earlier this morning, so WebEx isn't liking me. Is that any better?
This is Robin from IT, and Randy, it sounds like you're far away from your microphone. Like we can hear you, but it's very faint, and then all of a sudden you come in clearly. Yeah, it just comes in and then you fade back out again.
Yeah, I'm trying to figure out the settings on here. Is this any better?
No better. Okay, so down by your mute bar,
Yeah.
there's a drop-down arrow. Can you select a different microphone from that?
How about that? Is that any better? Probably worse.
No, it wasn't any worse, but no better either. Sorry. Maybe the volume on your computer, do you have that down too low?
I'll see what I can figure out here. Is that any better? Mm-hmm. Better. I've addressed that.
Oh. Was better for a second. Sorry, Randy.
Great. Hey, how about that?
Robin, is there a telephone number he could call in
Yeah.
on?
Absolutely. Let's have you do that and just talk through the telephone, Randy.
Awesome.
Thank you, Robin.
Yes. Okay, it's 415-655-0001. And the password on that will be 899-842-48.
So while Randy's calling in, could you envision it, Stephanie? Sorry, Stephanie.
Shelley, you've cut out as well.
Okay.
I mean, it wouldn't be a Friday and video calls without some technology issues. So I feel like this
Can
is
you hear?
par for the course for my week. So
Can you hear me now,
I can.
Spence?
Hey, Robin, this is Natalie from KLRD.
Yes.
Would it have anything to do with, the bandwidth? So like if we all turned our cameras off, would that help? I don't know if that would.
I mean, it could, but I'm not picking up any bandwidth issues right now at all.
Okay.
Shelley, are you traveling in a car?
Yes, ma'am. Sorry.
Yeah, see, I'm wondering if you're just going in and out of reception. I'm
We're
not sure
almost-
what Randy's issue is.
I'll stop talking until I get to a location.
Okay. So other folks kind of thoughts or input around the fines and fees and court costs, kind of the financial obligations.
This is Stacy Donovan. I like the idea of it being in this document, since I'm sure that's something that's easy for probation officers to refer to, and for them to, the probationer to take home and see it with all the other conditions. So I like that idea. I do understand that the costs are always different because the court has to ask their ability to pay, and of course, restitution is going to be different in different cases. So that's my 2 cents.
So Randy, would it be possible if we did break it down? Because I personally like that it's easy to see, this is exactly what I owe, but maybe word it somehow, pay costs as ordered by the court. If you don't have it, you leave it blank, right? And they sign it, but the journal entry is still your overriding document. Just trying to think of how we could, how to make it easiest for the defendant to understand, but at the same time, knowing that you might get somebody directly from court, you weren't in court, so you don't know what costs were ordered. And so maybe word it somehow that costs as, as directed by the court.
This is Jeff from KDOC, and are we using that portion just as to kind of put them on notice and give them a sense of what they might owe? Because I think we talked about removing the specific dollar amounts. So maybe there's some language that says, you may owe fees and fines as ordered by the court or your supervision officer to include but not limited to the following.
Yeah, and Jeff, I like the DOC standard condition. I like that it says pay restitution, court costs, supervision fees, and other costs directed by your, we'd say, supervision officer. But I think if we have those, that it'd be nice to be
Yeah.
able to include whatever fees it is. So if you don't have it, maybe it's something that the officer themselves can take out. I mean, I don't know if we want to be editing documents like that, but you know, it's like Stephanie said, judge stated, you know, it's a judge's order. So I think we definitely want to have that here. It's just kind of coming up with
Yeah.
that in between ground of how to list it.
Mhm. Do y'all like the list on how like this is listed out, kind of like almost anything that can essentially be assessed, there's a place to enter that. There's some other ones that are a little bit shorter in nature, like this top chart. But do you like having kind of the full list of what could be assessed, and then you're just filling in kind of what's assessed or required, so then that's all in one place?
This is Jeff again with KDOC. So let me ask, are we going to, so I'm fine with the list of them. It's whatever helps the officers and helps that person under supervision. But I want to make sure I understand, are we going to remove the very specific dollar amounts? Because it's going to, what I heard is it varies from individual to individual.
So Secretary Zabuda, you're talking about kind of here in the middle where it's like listing out these actual dollar amounts.
Yeah, and down on the list, there's some dollars amount down on the list.
Yep.
But typically, a lot
You
of
hear
those
me now?
Yes.
Okay. And those change sometimes. You know, sometimes the Supreme Court will change those amounts from year to year. So it might make more sense to not have a specific amount in there.
What we do with our form is we have it broken down kind of like that top box that was showing the different items, but not everything. But it's a typable form. So if the legislature or the court, you know, changes the actual fees or whatever, it's a type-in document that we use. And then we can fill it in that way. I don't know if I like the full list because so many of those we are not applicable to many of the clients. I like the shortened version with the other box a little bit better if we do put in actual fees and costs.
So this Jeff's mood again. Let me suggest again, maybe as a preface to the lists, you just say you may own fines, fees, or other payments. Fines, fees, and payments that you may owe are include but are not limited to the following. And then there's that list, and then the supervision officer can go through the ones that are applicable to that person, or create a separate, you know, that type in box or whatever.
I like that. I do. I like the proposed language that's already on there about pay restitution, court costs, supervision fees, and other costs as directed by my supervision officer. And then, yeah, it would be very easy to come up with another form that we could use to break down things. I don't think that's an issue. I don't know what you think about that, Spence, but
Yeah, I do. And I've got one question and then just a comment. And I guess I'll do my comment first because, you know, I think a lot of times as a defendant, you're sitting in court, all you hear is I'm not going to prison, right? And you don't listen to what those costs are. So I think it's nice if you can, if it's available at the time you do your intake, that there's a list that you can see. And I think that's 100% correct. You know, a lot of those, some of them don't hardly ever apply. You just rarely see. So I think having a shortened box with the main ones, court costs, fines, your supervision fee, DNA database fee, you know, attorney fees, restitution fees, those are all pretty standard ordered ones. If it's not applicable, you just leave it blank. And with the wording we have, I think that works. I would do we want to, on the proposed language, and I think specifically for restitution, right? Because the restitution is statutorily set a payment plan by the sentencing judge. So do we want to have pay restitution, court cost supervision fees as directed by the court or my supervision officer? So if they don't list a payment plan, you know, then the supervision officer still has the ability to inquire about payments and what's, you know, we can figure it out that way. But I think we might want to include by the court. And Judge, you could weigh in on that if you feel that that wouldn't be necessary.
This is Stacy Donovan. I agree. I think you should have something about the court as well.
So we have for the proposed language, pay restitution, court cost supervision fees, and other costs as directed by the court or my supervision officer. Financial obligations include but are not limited to the following. And then there would be a list of some of those most frequent financial obligations that would typically apply to almost everyone who's on some form of supervision. And then we could do an other or something underneath it where like they're able to add in kind of any of those other specialized ones.
I would add bids fee to the common list. The S is capitalized.
Oh, thank you.
Thank you for remembering that, Stacy.
Yeah.
Judge, sorry.
The DNA
Call me
database fee would
Stacy.
be, that's hard to do, Judge.
You said the DNA database, Spence?
Yeah, that for felonies, that's very typical. Did you have a supervision fee? I mean, yeah, I see that. Okay.
Yeah.
I don't think we need the statutory notations
Right.
on that.
Okay.
Jennifer,
I like-
maybe one more edit under the proposed language, on that proposed language. Pay the restitution, court cost, as directed by the court or your supervision officer. We've been using your in our other standards, not my.
Perfect.
Yeah.
I would spell out attorney
Okay.
and make it just attorney fee and supervision. Shouldn't that be singular as well? Or are there multiple supervision fees that you're thinking about?
Could we do a / attorney fee / bids fee? Is that, I mean,
Well, they're
I don't know if we-
separate.
yeah, I know. And I didn't know if we could combine those, as we don't always do both, but I can see the need for both.
Stephanie and Spence, on supervision fees, do you guys list out the felony and the misdemeanor supervision fees? And then if they go to communications and some agencies then charge an agency fee, how do you usually list that now?
It's just listed per, I mean, there's a fee for a felony and a fee for misdemeanor. So we just list, because that comes from the court order. The courts are the ones that direct if that fee be paid. So if it's ordered, we'd list it.
So Randy, our fees probably aren't going on the document now then.
Right.
Okay.
Can you hear me now? This is Randy.
Yes.
Oh, yeah, I was going to say, I think we just basically say they have to pay the court fees and then a supervision fee. We do note that on there. So there's a condition that says that they'll have to do supervision fees. And I think most agencies across the community corrections agencies across the state do charge a supervision fee. So I think that would have to be included if we're doing the other ones.
Do we list that though if it's not an order of the court?
It's a condition of supervision.
Concern. I don't think in our judicial district we list it because it's not ordered directly by the court.
Yeah,
By listing it, by listing it, it becomes an order of the court. Do you know what I mean? I mean, for us, we list that as a supervision condition, and then the judge signs off on it, so it is a condition of supervision. We're never going to revoke over it, so I don't know if it's worth it.
That's true, because the judge does sign on the final conditions. I just philosophically, I struggle with us having to charge supervision fees to accomplish supervision. I just, someday I'd like to see that not be the case, but.
I certainly agree.
And I know last year with the Reform Commission, and this might be kind of maybe something for, you know, once we're finalized with this, I know there was some discussion about fees generally and kind of the amount that the courts rely on fines and fees in order to maintain operations, and trying to figure out a way to right size that within the state so that there isn't such a reliance on fines and fees that can be so burdensome for folks who are part of the system. And so just kind of putting that out there in case the committee wants to also, you know, add in recommendations about the court or about, you know, to the legislature about tackling that issue, because I think there's recognition that there's some challenges inherent in tackling that, but that it's something that needs to be done at some point within the state.
I know it does. I don't think it'll hurt to mention, you know, the cost of fees for those that are under supervision. I don't know how we even begin to right size the judicial branch's budget with the way things are in Kansas, but I mean, it can't hurt to at least document in writing.
Are there other fees that aren't listed that we want to kind of add in and tackle?
Do you list in a category of other just in case there are? Or is that already on the list?
What about a KBI drug fee? I think we see that quite often, almost in all drug.
Isn't that considered? Hey, isn't that considered restitution, Spence?
I think it is, but
restitution.
I would, and I do agree that that's what it is. I only hesitate because if you put restitution and someone's like, you know, I think the nomenclature of restitution is, hey, I did somebody wrong, right? And I've got to pay it back. So I think just as I'm trying to put myself in the shoes of someone across the desk from us, is it easier to see that as restitution, or is it easier to see it as a KBI lab fee, which is what the judge would have said in court? But I get your point. So either way.
This is Stacy. I think that we should list the KBI lab fee separately to avoid confusion. And also it's now the court, if it is technically restitution, you know, we have to work out a payment plan while we're at the sentencing. So I don't want to be confused either. And also I would add on after bids, add application fee. So that's differentiated from the attorney fee.
Okay, so KBI lab fee, bids, you said application?
Yes, fee.
Okay. And I think these can be reordered, you know, if we need to as well. So bids, application fee, KBI lab fee, and bring up this other one here in case there's things listed here that would be helpful.
Did you list Senate Bill 123 fees?
No.
I think that's one we see a lot, and I think that might be a good one. I know that's another fee. Going back to Randy, kind of keeping this a little more succinct, and we keep expanding it, but I think maybe that's a good one to separate from fees or fines. To list Senate Bill 123 separately.
would you recommend both of these, the assessment fee and the offender reimbursement, or just the assessment fee?
I think you would want both, or you could just put maybe Senate Bill 123 fees. If they don't qualify for Senate Bill 123, they just pay the reimbursement, which is 125. If they do qualify, it's a $300 fee. So maybe that's just left to the officer to fill out either 125 or 300. Would you agree with that, Randy, Shelley, Stephanie?
I'm good with it.
Good with it.
You could put a slash and an S since it could be two different types of fees. I don't know if that makes it more confusing.
Just to maybe add one more, and I know I saw it on every case, but a fingerprint fee for arrest. Is that typical that we'd want a fingerprint fee added?
I think they had this, they had it on here. They had booking / fingerprint fee.
Yeah, I think that's the wording in the Sentencing Commission on a PSI. And I know we really wanted to keep this short, but I think just sitting, like I said, sitting across the desk, it's probably more helpful to see it listed and to know exactly what. Again, you know, it might not be something that we're specifically going to revoke on, or you know, if they owe tons of restitution and make $200,000 a year and they don't pay, then maybe you do revoke on that. But for the most part, you know, these are. I think it's just helpful for them to understand exactly what their obligations are when it comes to finances.
So then my question goes back to, can we, on the actual order, can we use that short proposed language and then just have an attached form that has it all separated out? Or do we have to have it all spelled out in the order? What's the best solution for that?
I'll pipe in. My only hesitation is if we're kind of looking at this as like a guidebook, right, for the probationer. If you just have it all, you know, together in one page, or if this flows into 2 pages or whatever, rather than having a separate document, I think that's a little bit nicer. But that said, I'm just one person on here, and if everybody else thinks it'd be better to have it separate, that's fine too.
I guess it depends on how long the document's going to be, because my initial feeling is if we can keep things to a page with all the orders listed out, that is a great thing for the client to refer back to. If you have a separate page, and again, I don't like more than one page for anything, but if we had to list everything out, if we had a second page that just had financial obligations on it, and that's where you can break it down, I think if I was receiving it, I would like that. Just have a page that has that and then a page with all the orders instead of having like flip through to look for, you know, maybe a specific thing. Again, that's just my own opinion too. And whatever everyone else thinks is fine.
So just a single page of financial obligations, which would list that only. So
Yeah.
that would kind of go back to what Randy said earlier, is if we don't know the cost when you get the probation and have to do an intake, then you can, you know, you don't have to attach that financial obligation page, but if you know it, then you go ahead and fill that part out as well and attach it to the order of probation.
Just wanted to show you my background. Okay.
That is not right.
I'm in Scottsdale. Okay.
Can we mute her?
We should.
I absolutely agree with what everybody just said. And Stephanie, that's kind of how I envision it. Like those are on the front page and then just the fiscal information is on that back. Great idea.
I agree.
Yeah. Yeah, I think too that I'd rather just make the rule that you got to pay the stuff, and then we'll provide you the amounts when they're available.
Just for clarification, Randy, I think we were leaning to envisioning where that would still be attached to the general conditions, just on its own page, so to speak.
I think that's fine. I'm flexible on it.
Okay.
Secretary Zamuda, how does that work for parole? Would these be things you'd list out, or would these be things that don't even apply to you?
This is Jeff Smuda. So Randy, I think there's a certain amount of them that might not even apply to us, but I think it's good to have the list. If nothing else, it prompts our supervision staff on the things they may need to research if they don't already have it in front of them. I don't have any problem with the entire list being on there.
I think then I know we've got this list here, but I would propose if we have a separate financial page that we kind of list it like it's in the Sentencing Commission in the PSI, that we go ahead and have the full list there. So it's just easier if you know the cost, you just go in and write it down. If it doesn't apply, you just leave it blank. But since we're doing a separate page, include more.
Include more than this list? Is this not pretty comparable to what's in the sentencing journal entry in the PSI, Spence?
I'm looking at the PSI list. I mean, it's got human trafficking fee, which isn't used often, but I just thinking, if that's what's ordered is if there are those cases, there's a domestic violence program fee, or
Okay.
assessment recommendations, community corrections fee, bids attorney fees, bids application fees. Other is lab, medical, witness, court appointed fees. If you had, and then we can still have an other where, say, it's an extradition fee, that you could add it that way. But then we're, as the judge orders that, because they're going to follow that list generally that's in the PSI, then that just would succinct with what our financial obligation page is. But if we want to keep it short like this too and just leave it as other, that's fine.
If we're going to list them out, I guess it makes sense to mirror it from the Sentencing Commission documents.
This is Stacy, and I'm saying this, and so you all know that I was the head of the Forms Committee at the Sentencing Commission for the last couple of years before I went to the bench. And those forms are ridiculous. So I don't know that copying the forms is necessarily good. They have to be absolutely complete. So I would ask the probation officers on here, do you think other is enough? Like, do you foresee it being too many other things that a court would impose that aren't listed in our top list, where you would want every single thing listed out like on the Sentencing Commission forms? Because I know that we're trying to keep things simple.
Yeah, the other thing that comes to mind for me along those same lines is I hate to leave all those blank and then my client come back later and say, well, I signed my supervision agreement and it didn't list any of those things, and now you're telling me I owe all this money. So I think that it cuts both ways where, that's where I usually lean towards the keep it simple. I don't know all your fees. Those are going to come up later. It may be 3 to 6 months before I actually get your bids fee from the court. So I'm not going to know that amount for potentially 6 to 9 months. So that's why I prefer, I'm certainly want to be flexible. And if we want to put on, that's great. I guess my thought is just that if I'm the probationer, I'm signing off on this supervision agreement, but a lot of stuff is left blank. It's kind of like having a other category on there, and I don't know what that other is going to be.
I don't think I realized that court, like attorney's fees would be determined later. Where I've practiced and now the different counties, everything was always set in court and ordered by the judge, and it didn't change other than additional probation fees that the court would just make a blanket statement about, but I didn't realize the attorney's fees and those types of things could change or be added.
Yeah, typically we get those months after they've been sentenced. It's several months. We get somebody from the clerk's office passes it over to us. We have to do an order that adds those bid fees onto their court ledger. So I've honestly had people that were almost done with their 12 months of supervision before we had that information. I don't understand why it's done that way, but it's done that way.
I'm sure that's a terrible conversation to have.
It is.
Jennifer, do you want to facilitate where we are thus far?
Yep. I was trying to take notes, reflect the conversation, and add it in. So what I have is that the proposed language that would be on the general conditions of supervision would be pay restitution, court costs, supervision fees, and other costs as directed by the court or your supervision officer. So that would be pretty succinct. And then there would be financial obligations listed out. They would be on one page, so kind of a dedicated page for financial obligations that I wrote attached to the general conditions, or kind of like a continuation of general conditions. There would be a financial obligations page. And that would have language similar to like financial obligations include but are not limited to the following. There would be that list of financial obligations that you see on the screen. There's an ability to add other. I think that's kind of where we're at, is should it be kind of in a pretty exhaustive list? And then things are just, 0 if it doesn't apply, or NA if it doesn't apply. Or should it be kind of a more robust or a streamlined list, and then additional things are added under other? I feel like is where the committee is at right now.
Thank you.
Mm-hmm. I believe in one of the sample documents that were sent along. Oh, I wouldn't be able to dig it out. To dig through some stuff to try to find it. But there were some that had kind of a more exhaustive list in the example, like conditions supervision that were sent out, where it's kind of like a full page document almost. And they're filling that information in versus streamlined. What would be easiest for staff? Because I feel like there's two things, right? There's the readability for the person who's on supervision and kind of the understanding, but then you're also thinking about the ease of use for staff. Is it easiest to have that be a more extensive list and it's just filled in what's required, or for them to have to add in kind of those things?
I think it would be easier to just tab through through it and add in the amount. And maybe is it's its own page with the list, and if then it's marked, and then so there's needs are
Kelly, you were
about it, we get
a
it,
little-
that information.
Shelley, you're cutting in and out for me. I don't know if you might be. Oh, I see Stephanie nodding her head. So I think you're cutting in and out for other folks. From what you had shared, Shelley, or what I could pick up, I could be totally off track here, but it sounded like you were going down the lines of it might be more user friendly to have a more exhaustive list than to have a shortened list and have to write out what kind of those additional things are for staff. Is that on track?
Yes. Yes.
How are other folks in the room feeling about that? Okay. I see heads nodding, but there's only 3 of you on video. So am I taking silence as consent that an exhaustive list would be easiest for staff, and then they're just filling in the dollar amounts for the ones that pertain to that individual? Right? Okay.
Yes.
Okay.
That's fine.
Yes.
All right. Okay.
Can you hear me now?
You didn't talk enough to know how bad it may or may not be cutting out, but I could hear you.
Okay.
So does it make sense? Trying to see here what time we're scheduled to. Okay, so we have another half hour. I'm wondering if it makes sense. I don't know if we have another meeting scheduled before. I think we do, before the report is due to the Reform Commission, but I'm wondering if it would make sense. I think I can go through some of the other conditions of supervision that we were sent previously and list out kind of what all of those, a more exhaustive list of fines and fees that we found in other conditions of supervision, and then vet that with the group and making sure that we take out any of the dollar amounts, since those are subject to change, making sure that we can pull out the statute references, since that isn't necessarily needed on those documents, and present that list at the next meeting to the group. Does that make sense?
That works for me.
Okay. Do we have another meeting scheduled, or is that something that we would do via email?
is Stephanie with CSG. Jen, we do not have another standard conditions meeting scheduled, at least on my calendar, before November 1st. And I definitely think, and it's the trend in other subcommittees to definitely get another meeting in before the end of the month, because just for review purposes, and I think some of the tech difficulties from today might be facilitated by having another meeting. I know the last meeting there was some calendars are real tight, but maybe there may be a meeting either next week or the following week is a good idea. I will say that on the 29th, which is the last Friday of this month, there is a diversion meeting scheduled at the time this usually takes place. This subcommittee meets, so we would need to kind of work around that. There's quite a few members on both committees, actually. So just to kind of keep that in mind, next Friday, there is no meeting scheduled to take place if folks were available the 22nd.
We have a meeting scheduled on the 22nd.
Do you, Jonathan? Okay.
The incentives.
That one is scheduled at 10:30. You're right, 10 in the
Yes.
morning. Yeah, 30 to 11:30.
Okay.
Would this committee be available at say noon on the 22nd?
I am not.
Okay. Spence, do you have a different time in mind that may work for you? That might be helpful. Yours and Shelley's go together.
I don't know how essential I am, but if we're looking at Friday, I would be available 1 o'clock on, but nothing before 1 o'clock. On Thursday, and I apologize, I had to step away just for a second. On Thursday, I'm available until 1.
Okay. So other voting members of the committee, I think this is really falling on probably those folks. Secretary Zamuda, do you have a preference for next Thursday or Friday, either before 1 on Thursday or after 1 on Friday?
Jeff Smuda, I would prefer before 1 on Thursday.
Okay.
I think that was an option that you listed.
Yes. And then let's see. Shelley, or if you can hear us, would before 1, anytime before 1 next Thursday work for you? Shelley, you're on mute if you are talking. Okay, she may have been out of reception. Mr. Ogletree, would Thursday before 1 work? Any specific time work for you on Thursday the 21st before 1?
I can make it work anytime before 1.
Great, and then I'll move to the non-voting members. Randy.
This is Natalie from KLRD. We scheduled, or Chairman Bennett scheduled a race subcommittee meeting for 12 to 1 on Thursday, the 21st.
That's great to know.
So, I don't think I sent out that notice yet, so just wanted to let you know.
No, appreciate that, Natalie. So anytime before 12. So Randy, could you make any time before 12 work?
Yes, ma'am, that'd be fine.
Stephanie?
I have a board meeting scheduled at 10 and an appointment, but I might be able to participate by phone if it's not at 10 o'clock.
Okay, so why don't we do 11 a.m. on the 21st. Standard conditions. Shelley, I really hope that works okay. I know we're having some tech difficulties for you. But we'll go ahead and schedule for.
It works.
Perfect. Okay. So next.
I had to get him muted.
Okay, good. Next Thursday, the 21st at 11 a.m. And we'll continue working. And we'll get a Zoom or WebEx, either one. Maybe it's back to Zoom. That tended to work. I'm seeing some nodding heads. Seem to work a little bit better. So maybe we'll go back to Zoom for that one. If that works for everyone.
Stephanie, can you hear me?
Can.
Okay, 2 more things we have to wrap up next week or the week after is firming up the language on the search and seizure, or well, not seizure, but just the search. And I did get feedback from Tabitha, Smith County Attorney, on that. And then if we want to make any recommendations in general for special conditions. So just a couple more things to talk about.
Okay.
I can't spell today. It's Friday. Search and seizure. Somebody help me.
I have one follow-up question. Just knowing how hard it is to schedule, do we plan to meet the last week of October sometime? And if so, can we go ahead and schedule that now to get it on our calendars?
I think that's a great idea.
Definitely. So keeping with a Friday theme, a Thursday, Friday theme, like I said, on Friday the 29th, there is a diversion meeting scheduled at 12:30 Kansas time. Could we do before that meeting? Would that work for folks? So what would that be, 11:30 to 12:30, or 11 to 12, give people a little bit of a break? 11 to 12, I'm seeing nodding heads.
That works.
Okay, great. So why don't we do, Spence, does that work for you, 11 to 12 on the 29th?
Yes, it does.
Awesome. Secretary Zamuda?
That'll work for me.
Great. Awesome.
Thanks for putting that on the calendar now. That helps.
Definitely. I agree.
And I know we have another half hour left for today. I wanted to, so while we're talking about the next meeting, so I have down review the final list of conditions of supervision. So I can help Shelley. We can put this on kind of one document, the conditions of supervision that the committee talked about, refine any language that we need to make, firm up the language around the searches, and then review that kind of exhaustive list of the financial obligations that would be developed. And my understanding, and let me know if I'm off track on this thinking, is that kind of whatever it ends up with the recommendations for the general conditions of supervision and kind of trying to standardize a little bit that form and format of kind of what that looks like for the state, it might be best to develop a form through the Sentencing Commission. Is that kind of what we're thinking? Kind of long term, if that everything passes through the Reform Commission, that they would help with kind of housing that form and that format and document.
That's kind of what I was thinking, and I was hoping maybe some of their staff could help us with a final look of it, I guess.
Yeah. And then I also have listed here like any additional recommendations from the subcommittee that you might have around, you know, I think there's like just fees generally, but then also I don't know if there's additional recommendations that the committee wants to make in terms of, you know, if the Reform Commission adopts it, you know, are there recommendations around training? So I know Johnson County is working on a project with Robina to help them tailor special conditions of supervision to risk and need for the individual. And so, you know, some sort of kind of training or education for, I think, not only the courts, but then also supervision staff as well around some of those best practices in condition setting and how to tailor special conditions to the risk and need of the individual and what's most effective. And, you know, or are certain conditions not quite as effective, things like that. If there's training or recommendations that the committee wants to make in terms of kind of that, what that should look like in the state, or kind of moving forward in terms of how to tackle this holistically. Are there other items that the committee wants to make sure that's addressed at the next meeting or prior to the Reform Commission?
I was wondering if we could talk about briefly, not today, but in the next 2 meetings, any recommendations we may have on how to integrate, or if we want to make a recommendation that the parole board and Secretary of Corrections or DOC, I'm not sure who has the authority, but to look at where it's appropriate to streamline them to make them look like the ones that we came up with. But certainly knowing there's, you know, unique ones to parole, but if there's anywhere we can make it common language, do we want to make that recommendation?
This is Jonathan Overtree. I wouldn't be opposed to that being common language where it's possible, because there's definitely some differences here and there, but where it can be, I think the common language will help across the board.
And then before the recommendations would go to the Reform Commission, does the subcommittee need to kind of mock up what changes might need to be made legislatively with how the conditions are listed in statute currently? Is that something that also needs to be on the agenda? Like, which statutory changes would you recommend being made?
Yes, and I don't mind. I've already kind of started working on that as we've gone, so I don't mind submitting that to the subcommittee to take a look at.
Just brainstorming, do we foresee anybody on this group, because I think we're well-rounded, any stakeholders, any other people that may object to any of this? Offhand, I don't, but I want to, if we think that there may be a group of individuals that say, hey, this just doesn't work, I think we'd want to address that somehow, as in, listing that there may be groups that, it may take education to understand why we've done it this way. Kind of not just for our officers if this passes or whatnot, but more just different stakeholders. Again, I don't foresee anybody that's going to come back and say, hey, this just doesn't look right, we shouldn't do this. But I think we should be cognizant that if there are other groups out there that may not agree with this, we want to be able to address issues before it came up.
This is Stacy. Do we have anybody from Wichita on here? No. Just from my 5 years on the Sentencing Commission, Sedgwick County, they are the biggest, and they have often been the ones who have the strongest opinion, in my personal experience, about any kind of changes we made. They're still, at least to my knowledge, not always using the proper journal entry form and that sort of thing. So I think it would be a really good idea to maybe run this past some people down there.
And are you seeing that, Stacy? I know Stephanie from CSG, I don't know if any of the judges that we have coming up that will be meeting with her from Sedgwick County. So I'm thinking the judiciary, but then also, you know, are you thinking someone from the courts or like court services, like chief court services officer, you know?
That's right. I was thinking of chief court services officer, since, you know, this is a tool that they'll be utilizing.
Yeah.
I mean, in theory, most directly with the probationer. So
Spence, off the top of your head, do you remember the name of the chief court service officer down in Sedgwick County?
Of course, it's Melinda Wilson.
We have not spoken to Melinda.
And you know, part of me, I do agree that Sedgwick County often has done their own thing in the past. I think as a judicial branch, we've really tried to push following legislation, and I think if this were to, I mean, and this kind of goes against what I've just said, but if this were legislatively passed, then you know, the directive is they're going to have to follow that, the conditions as stated by statute, right? But again, they may be a stakeholder that says this just doesn't work for us. I wouldn't foresee so much court services in one district raising a huge issue about this. I would think it may come more from if this is judges just want it, you know, as we know, if judges want it that way, they might object to this, but I don't see that court services would be a big factor or a stakeholder in this, would have much dog in this fight, I guess would be the best way to say it.
well, that's good. I just say that because we
Yeah.
had
Right.
such a problem, and still with they're not
Sure.
using the journal entry forms.
Yes.
They've got their own
Yeah.
form, and while it is the law, they are not following it, and it causes a lot of headache. So I just, out of an abundance of caution, that's why I mentioned it.
And I agree. I think those are valid points for sure.
Yeah, and I know from the focus groups that we conducted, I mean, I think you hit the nail on the head with kind of, there was widespread agreement and kind of around the need for more standardized conditions of supervision across the state, and kind of they love that idea. I think kind of the big rub for a lot of folks is going to be those jurisdictions who have worked really hard on their forms within their court or judicial district, and kind of revising those, and kind of the labor of love that went into those in the individual jurisdictions. And this is kind of taking that to an extent away from them. And so I feel like the concept is supportive, but losing kind of all that work is where the challenge may be.
Yeah, and I agree. And as the state, and this is kind of a side topic, right? But as we go forward with Odyssey moving into all courts, forms will really be standardized. There's actually a process that forms will have to be approved statewide. Jurisdictions won't have the ability just to enter individual forms at any time like they've been able to do in the past. So really, I think we're really addressing some of these issues with the new systems that are moving out. So you know, I think districts are learning this as they see more of how this rollout's going. So it might not be quite as big an issue as say if this was coming around 2 years ago, what it would have been.
That's a relief.
I know Shelley signed off. So just looking at our last, I know we've got 15 minutes, and Jennifer, you're kind of leading this, but did we want to, I think the only other the form or the condition that she mentioned was sanctions and incentives. Do we want to try to tackle that the last 15 minutes, or not to take over at all, Jennifer. I'm sorry that I might sound that way, but I just wanted to see if we wanted to do that so that we could have the basic framework of this done before our next meeting.
Yeah, you are perfect, Spence. I thought you were going to run the show, so I'm happy that you are jumping in
Sure.
with some additional stuff. So I want to make sure that we were kind of getting that exhaustive list for like what the remaining subcommittee stuff work is, so that we can try to move through that. Pat, it sounds like you might have, or looks like you might have something you want to add.
Yeah, and I don't know if this our standard terms is the place to put it, and it may much go better in the actual legislation that you do, Spence, when you recommend some incentives and that kind of thing. But my question was, did we want, since this is the form that everybody will see, some sort of statement like the one they discussed at the general, that Mark Bennett brought up at the General Criminal Justice Reform Commission in their September meeting, something like a statement to the effect, would early discharge from probation or the reduction or elimination of various conditions of probation may be considered and may be appropriate in an individual case when there are risk-reducing factors such as employment, obtaining a GED, or the early discharge of debts. I mean, that's a statement that I wrote up based on what the discussion was at the Criminal Justice Reform Commission. But my question is, maybe this, I'm not sure it is the right place in our list of standards to indicate that here we have this list. Now there could be, reduction or elimination of standard of requirements, based on, incentives or risk reducing behaviors such as, getting a GED or having employment. And I don't know, and it may be the kind of thing where you're going to put that policy, Spence, in one of the statutory points that you do about specific reductions in probation. So that was my only thought. Since we do know that incentives are the best at risk reducing and eliminating criminal behavior, I'm all for putting that policy in front of whoever, whenever, and I don't know if this form is the right way to do it or not, but I thought I'd at least raise it for people's consideration. And that's all I have to say.
Pat, I was thinking how silent you've been this meeting. So I'm glad you said something, but I think as we've talked that all of these committees are really intertwining. Stephanie's pointed that out several times, and I think it'd be good for each committee maybe to just point out that these are all kind of an intertwined workings, that they're not standalone, but they would work best as a group. And I think we could each one of these committees state it somehow in our recommendations.
Spence, I'm good with that as just a general statement of the Criminal Justice Reform Commission, sort of as a policy. My only question is, do we want it actually on a form that people then have to read, have to consider, including the person who's signing the form? I don't know. I see some general benefit, kind of. I mean, it's not the biggest deal, but I thought I'd raise it as a possibility.
So thinking, with the one condition that we had that Shelley had mentioned to put on was about sanctions, right? And so as I look at the DOC standard, it says if you do not comply with all conditions, sanctions will be imposed. And as I've thought about what we've been talking about, I was kind of wondering if we could use that language, but say, and just part of this condition, if you do not comply with conditions, sanctions may be imposed. And then maybe we can include language somehow to include, you may also have the ability to earn incentives by following all conditions of probation. I mean, just something general like that. So that it's a condition that they understand that they can be sanctioned, but that, it's not that they will be, it's may or may, for may have incentives or may have sanctions. Would something like that, do you think, satisfy what you're headed towards?
Yes, I do.
Okay.
I think, and I think that's exactly the right place to put it because it balances the two.
So let me, I'm gonna copy this. Apologies if you hear my dog snoring. You hear some muffled noises, that's what that is.
Just so we don't hear you snoring.
It's not me, it's the dog, I promise. So, and then we would want, so are we thinking two separate ones, like one related to sanctions and one related to incentives? Or having those combined into one condition?
I could go
One of
either
the
way,
things
in the same paragraph or in two separate paragraphs.
One of the things that I would question the evidence-based practice of is referring to a drug and alcohol assessment as a sanction. That's not really, should not be used as a sanction. And we address it elsewhere.
And I'm wondering if, listing out potential sanctions is even needed. So a lot of times, I know in Kansas you have this with some of the different community corrections programs, and you also sometimes have this in terms of probation or kind of with parole supervision, is that certain sanctions aren't always available kind of statewide, or, some of it is based on the location. And typically there's a different document that covers kind of the behavior management piece with the sanctions policy, the incentives policy, kind of, what they need to do to receive certain sanctions and incentives. And that doesn't necessarily need to be listed out in the conditions of supervision, right? So we could almost take, yeah.
I would probably lean that way as well, Jennifer, just that this might be part of a conversation I'm going to have with a client, but I don't know that I need it as a condition. I think just like certain sanctions may not be available everywhere, certainly not a lot of the incentives will not be available everywhere. And at this point, we don't know what incentives will be available.
So I know every district I've worked, we've had, kind of like was just mentioned, a separate form that we do at intake that states what sanctions are available. And I think that, I see Randy shaking his head. Yes, I think a lot of agencies have that type of form that lists the sanctions. So, do we need to include a condition of probation about sanctions and incentives? If most agencies, and maybe this is a question for you, Judge, do you think it'd be beneficial when you have your orders and you sign orders that you want something on there, you would like to see something on there that says, sanctions are available, some term like that? Do you think that's beneficial, or is it, it's something we're statutorily allowed to do? Agencies have their own sanctions, as we've all stated here. So do we just keep it as a separate page? And it could list that sanctions and incentives are available, not just, that it's an encompassing page.
No, I hadn't thought about it.
Sorry to put you on the spot, Judge.
No, I'm fine with that. It's just, I'm trying to decide philosophically, maybe that's not the right word, but we are laying out these conditions of probation. They're signing their name to it. The court's signing it. I like the idea of putting in there, having it somewhere written that, if you do well, we know what the law is, that your time on probation can be shortened, that sort of thing. But I don't know, as far as the conditions are concerned, or I mean, the sanctions are concerned, I think those are different with other counties. Also, I mean, that's something I'm hoping their attorney is talking to them about. Not that it would be bad to tell them on this document, but I don't know that they have to sign off on that.
Right. And as you talk more about that, Judge, I think, we're really, other than, well, as we put these conditions together, we really focused on, if they don't do this or they don't do this, then we can, that's a violation of the direct order. We can go back to court. They might end up serving their sentence, right? By listing that they, if you do not comply with conditions, sanctions may impose. Is that actually a condition of probation? Or is that just something that occurs if they don't follow conditions? So does that need to be an actual condition of probation that sanctions may be imposed? Just kind of looking at it as an order versus, what could happen.
For us here in Reno County, what we do is we have an acceptance. So at the end of the conditions, before where the client signs, there's an acceptance. So there's this paragraph that says that they understand the rules, they agree to comply with them, they understand that the court may modify their probation, which would mean longer or shorter, and some of those things. And so I think that there's an opportunity to put it in there, but maybe it's not as a listed numbered condition. It's just part of the discussion at the end of the document to say, I understand these conditions and I agree to abide by them. And I could get off early based on my behavior, or I could have sanctions based on my behavior.
I really like that idea because I think most conditions have that general acceptance where it's, I've read and understand all these conditions. I will abide by them. And then we just include a statement that failure to follow this may result in sanctions, or likewise, by following incentives may be provided as well. I mean, some general term, but I like that it's just a general statement right before they sign their name. Good idea, Randy.
I do too. We have that here in Douglas County, but we don't have any of the positive stuff in it, just the negative. And then we also have the last line is about waiving extradition. Right.
Yes.
Yeah, I think that's very important. I think we actually do include in ours that it says that I understand that if I fulfill all the conditions of this intensive probation, I would be discharged from my sentence that has been imposed against me. But I think you could include in there just that aspect. But again, if we don't know what's going to happen legislatively, I kind of hate to recommend we include it in the conditions and then the other piece doesn't get approved.
Yes, that's a great point.
I wouldn't want our document to not get approved because the early discharge does not move forward.
So I was typing some. My multitasking, it's a Friday, isn't always on point. What I have written, I was trying to kind of summarize what y'all were saying is, if you do not comply with conditions, sanctions will be imposed. You agree to comply with all sanctions imposed. Compliance with conditions of supervision can result in the reduction of conditions and potentially the early discharge from supervision. I feel like this needs a little bit of love and wordsmithing, but also recognizing we are at, I was going to tell you 11:30, but it's 1:30 where you're at. So recognizing we're at time and want to be respectful of y'all's time. So I think this is one, like, we can add it to that list of kind of conditions and wordsmith it at the next meeting to kind of get it refined to the way that's going to be workable. Does that make sense?
Yeah, it sounds like we're at a really good point with that, what we want to do. So yeah, that's an easy one to fix next time. I say
Yes.
easy, but I know how our groups have gone, so that could take an hour.
Yeah. But I think we'll pull out all the madness from the form and just list out the conditions of supervision, which I think will make it much easier to see them kind of right next to each other and kind of start going through that refinement at the next meeting, which sounds great. And we already have our times, so it's fabulous. Y'all have a great weekend. Hope the weather's nice. Enjoy some pumpkin patches, and we'll chat with you next week.
Bye all.